Welcome to Crime in Court. My name is Heather, and this is an update in the Idaho 4 case. So, just recently, the state of Idaho, was it yesterday? I think it was yesterday. As I record this, it is 8/15, August 15. Um, so they just recently dropped this filing, and it is a response to the defendant's motion to change venue. So we're going to go through this real quick and or not real quick, but we're going to go through it and discuss. So we've already gone through the defendant's motion to change venue. It was in multiple parts and I didn't even read the whole thing because it was very long. But now we are moving on to the state's response to that. So let's see what they have to say. Comes now the state of Idaho by and through the Latah County prosecuting attorney, so Bill Thomas, and objects to defendant's motion to change venue. Well, what a shocker. They object. It seems like lawyers just can't ever agree on things, isn't it? Like lately, all these trials that I've been watching, they're so polarizing and the attorneys can't come to agreements on things, so that's why everything gets fought, everything gets sustained, everything gets motions to keep things in and out and whatnots, and it's crazy. Like I just don't understand. Aren't attorneys supposed to work together and come to agreements on things before it gets that far? Most of the time, before it even gets to trial. I mean, I'm sure that's happening too, and we're just seeing the ones that go to trial, but still. All right, so I think you get my point. They just object to object, I think, on a lot of times. They just don't want to agree. So the defendant has filed a motion to change venue requesting that the trial in this matter be moved to Latah County, where the offenses took place, to Ada County, some 300 miles away. To support his motion, he conducted a survey of prospective jurors in Latah County, Ada County, Canyon County, and Bannock County. But far from demonstrating that a Latah County jury pool has been uniquely subjected to an utterly corrupted environment, as defendant argues in his brief, the data show that pervasive and wide-ranging coverage of this case throughout the entire state of Idaho has led to high case recognition among survey respondents across all four surveyed counties. Yes, that is true. However, they showed way more bias in Latah County, and that is what the survey data showed. And that's what they argued. There was much more bias. People in the surrounding counties said that they would be more willing to listen to evidence before they just determined that he was guilty, which a lot of people in Latah County said, yeah, you can't change my mind. He's guilty. What you going to do about it? So those aren't the people you want on your jury. Anyways, um, where was I? So the court should decline defendant's invitation to parse and split hairs over an incomplete data set to reverse engineer and transfer to Ada County, which, according to the defendant's own experts, has received the second highest amount of media coverage in the state and where a statistically greater number, albeit slight, of the survey respondents familiar with the case believe defendant is guilty. Um, A greater number, albeit slight, of the survey respondents familiar with the case believed that he was guilty. I don't know if that's what if the data showed that necessarily. I'm I'm finding it hard to remember it saying that. The court should deny defendant's motion and instead focus on crafting remedial measures to ensure that a fair and impartial jury can be seated in Latah County. So obviously, Bill is saying they didn't meet their burden. They didn't prove that we need to move it to Latah or out of Latah. Here's his legal argument. Although the government generally must prosecute an offense in the county where where it occurred, a court may change the venue to another county in limited circumstances. First, a court must change venue to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Second, a court may, but is not required to, change venue for the convenience of the parties in the interest of justice. In this case, defendant has asked the court to change venues on both bases. For the following reasons, the defendant has failed to show that either of the circumstances applies. Number one, defendant has failed to establish that a fair and impartial trial cannot be held in Latah County. I don't know. The defendant has argued that due to pervasive publicity in this case, a change of venue is appropriate. Defendant further claims that the atmosphere in Latah County has been utterly corrupted by media coverage. It is undisputed that defendant has a constitutional right to a fair trial with a fair jury, a panel of impartial, indifferent jurors. On a change of venue motion, it is defendant's burden to show a reasonable likelihood and pretrial publicity will deprive him of a fair trial. However, where pretrial publicity is at issue, a presumption of prejudice necessitating a change of venue applies only at the most extreme of cases. Well, I would say this is a pretty extreme case. The mere fact that the crimes reported by the media are gruesome or memorable does not render the publicity inflammatory to the extent of requiring a change of venue. No, but it does when they're all calling Bryan Kohberger this monster and saying things like that and causing a panic and fear to wave over the um, citizens of that town. It's personal to them because they had to live through the fear of it. So they do have a prejudice, and that is what the surveys proved, in my opinion. Although Bill has a different opinion. The mere fact that the crimes reported by the media are gruesome and memorable does not render them inflammatory. Um, the United States Supreme Court has also explained that juror impartiality does not require ignorance. So you don't need to have never heard. Whoops. It's not necessary that you are completely ignorant of the case or never heard of the case. You could have heard of the case and still give a fair trial. It's things like, but then that's the problem because you're letting them on the jury saying, yeah, I've heard of it, but I'm not going to let it affect me. But they still have that bias because they were in the same county that it happened and maybe they were the town next over and they were fearful, and that still weighs heavily on their decision making in the jury box or in the jury deliberation room, I should say, or both. All right, so in determining whether pre-trial publicity has risen to a level that justifies a change of venue, Idaho's appellate courts look to a series of factors: the accuracy of the pre-trial publicity, the extent to which the articles are inflammatory, inaccurate or beyond the scope of inadmissible evidence, like maybe DNA on a sheath, touch DNA that might not even be admissible in court with when we know how it came to be and how it was tested, that kind of thing. The number of articles, whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial, and the amount of time that passed between the coverage and the trial. The United States Supreme Court has held that only in the most extreme cases is a defendant afforded a presumption of prejudice based on pretrial publicity. In a sorry, I don't want to read those. Uh, so he's saying neither of these things apply here. Let me just read it. In a bank robbery homicide, defendant afforded a presumption of prejudice where his videotaped confession during a police interrogation was aired on local news 3 times and seen by thousands. That would be very prejudicial. Um, and then in this other case, State versus Estes, during court hearing proceedings, a judge allowed unmitigated camera access to the courtroom, including the filming of jurors' faces. Neither of these cases apply here. Defendant in this case did not confess to the homicides, let alone on video broadcast to thousands, and it is the state's understanding that the court will not follow the filming of jurors' faces at trial in this case. However, they might be referencing press conferences with certain law enforcement that might have said certain things. I don't know. A lot of times, what law enforcement says and what's admissible in a court of law are two completely different things. And it can totally prejudice the people who follow that case or the media or whoever, by getting that out there. Like the Delphi case and all the press conferences that they had in that case totally prejudices whoever they arrest. It doesn't matter who they arrest. If you look at it this way, the prejudice happened before they even arrested him. In this case, in Idaho 4, in Delphi. So the media, the law enforcement gets out there with their press releases. All of this talk about the crimes is already out there and prejudicing the public. So therefore, the bias is already created. So when you walk into that room and you're asked, have you heard or read or seen anything on this Idaho 4 case? And you're like, yeah, I have, but I can keep an open mind and I can be not biased. You're not it doesn't necessarily work that way. You can't It's not a switch you can just turn off. All that stuff that you heard about, read about, seen, gossip by the water cooler, you take that information in and you process it, even if you don't know you are. And it's somehow, or another, you create thoughts and feelings about what you're taking in. And that can still affect your case or if you're on a case as a juror. So just, you know, just because you say that you can be biased or unbiased doesn't mean that you can just put those things out of your mind and move forward without any bias. And I think that's an important factor when it comes to venue change, which probably isn't going to get as much play in the motion here or in these motions, but I think it's important that we, consider that. Anyways, so the defendant urges this court to find that Shepard versus Maxwell, another U.S. Supreme Court case, applies here. That's according to the defendant's memorandum in support of the change of motion. They cited Shepard versus Maxwell, but Shepard is wholly inapplicable to this case, according to Bill Thompson. In Shepherd, Bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom, hounding much of the participants at trial. Within a few feet from the jury box and counsel table sat some 20 reporters staring at Shepherd and taking notes. The Shepherd court went on to explain the extreme nature of the media participation at trial. The erection of a press table for reporters inside the bar is unprecedented. The bar of the court is reserved for counsel, providing them a safe place in which to keep papers and exhibits and to confer privately with client and co-counsel. It is designed to protect the witness and the jury from any distractions, intrusions, or influences, and to permit bench discussions of the judge's rulings away from the hearings of the public and the jury. Having assigned almost all of the available seats in the courtroom to the news media, the judge lost his ability to supervise that environment. The movement of the reporters in and out of the courtroom caused frequent confusion and disruption at the trial. And the record reveals constant commotion within the bar. Moreover, the judge gave the throng of newsmen gathered in the corridors of the courthouse absolute free reign. Wow. I mean, what? This is crazy. But they're saying all this stuff doesn't apply. But whatever, that doesn't mean that the portion of the case law that Ann Taylor cited isn't applicable, but they're trying to say that it isn't. So it's, how you interpret words. It's so crazy to me that one person can get one thing from case law and somebody can get something else. It's wild. That's why I like to look at these things in different ways. Anyways, moreover, the judge gave the throng of newsmen gathered in the courtroom free rein. Participants in the trial, including the jury, were forced to run a gauntlet of reporters and photographers each time they entered or left the courtroom. The total lack of consideration for the privacy of the jury was demonstrated by the assignment to a broadcasting station of space next to the jury room on the floor above the courtroom, as well as the fact that jurors were allowed to make telephone calls during their 5-day deliberation. That's interesting. In this case has nowhere This case has nowhere near the chaos present in Shepherd. Oh, I beg to differ. As the Shepherd court explained, the carnival atmosphere at trial could easily have been avoided since the courtroom and courthouse premises are subject to the control of court. Here, the court has scrupulously avoided such an environment. The court entered a non dissemination order early in the case, which only causes more speculation and misinformation to get out, in my opinion. When the small press pool that was allowed in the courtroom failed to follow the court's instructions as to filming or photographing the defendant, the court disallowed any media filming, photographing, or audio recording of court proceedings. Words are hard, okay, guys? Don't judge. This court has previously taken precautions to avoid the circus like environment described in Shepherd, and thus Shepherd is easily distinguishable and a poor comparison to this matter. But that's not what she was comparing it to. Um, I don't know. I don't remember her exact arguments, but I do remember that she had valid points that pertain to Shepherd, in my opinion. All right, so as the case law makes clear, the test is not knowledgeable of the case, but rather partiality. Thus, the fact that Latah County's survey respondents had the highest percentage of knowledge about the case compared to other counties is far less significant than the fact that Latah County survey respondents had the least amount of overall prejudgment among the counties. I don't know about that, but okay. I don't know how he gets to that, but all right. I'll read that again. The fact that Latah County survey respondents had the highest percentage of knowledge about the case compared to other counties is far less significant than the fact that Latah County survey respondents had the least amount of overall prejudgment among the counties. I don't think that's true, though. Was that the case? I don't remember. Her I don't know how they're getting to that, but okay. The survey data provided by Dr. Edelman is inadequate to justify a change of venue. It is not reported how many individuals declined to take the survey, raising serious concerns about non response bias. A glaring omission in the data provided by Dr. Edelman is the lack of any information about the number of individuals who were contacted but chose not to respond to the survey. Why is that so important? This is important because non participation bias can change the outcome of such a survey. And they're citing this website. As the authoring as the authoring of the 2017 article promulgated, hard word, by the Pew Research Center, telephone poll response rates stabilized at approximately 9% after years of decline. While the Pew Research Center article acknowledges that low response rate does not necessarily lead to a conclusion of bias across all subject matters, low response rate can skew results in specific areas. For example, individuals with high civic involvement are overrepresented in surveys. As the Pew article explains, telephone polls greatly overstate civic engagement, probably because of non response bias. As has been established in previous work, the people who answer surveys are likely to be the same people that are involved in their community's public life. They are joiners. Such a phenomenon could easily play a role here, where at the very outset of the survey, respondents were told that they are being asked for opinions about an upcoming jury trial. Sorry, I'm trying to readjust here. This court must ask itself, would an individual who was asked for their opinion about an upcoming jury trial continue a survey if they had no opinions about any upcoming jury trials? And once the survey started, would a prudent, thoughtful, and conscientious person who is reluctant to pass judgment with limited information opine to a stranger whether they believe in criminally accused is guilty or of homicide? I don't think that's a good argument. The court should also consider the fact that while the survey respondents were told that the poll was not political or sales related, these survey respondents were never told why they were being asked. Who cares? They had no way of knowing whether the poll was being done on behalf of the news media or a true crime blogger or for some other purpose. And that's fine. They don't need to know because knowing might even bias their answers. So, not knowing is, I think, a better approach. While they were told their responses would not be made public, they were never told whether they would be recorded. One only has to exercise common sense to see that there are innumerable reasons why prudent, thoughtful, deliberative, and conscientious individuals might hesitate to complete such a survey. Why? I don't, That's weak. A weak argument there, I think, from the state. Defendant's flawed hypothesis is that if 98% of the self selecting group who voluntarily chose to share opinions about an upcoming jury trial have heard about this particular upcoming jury trial, then 98% of all citizens who are summoned for jury duty will have also heard about it. The court should reject this illogical leap of faith and embrace a more practical inference. It is more likely that a voluntary survey that begins by asking individuals to opine about an upcoming jury trial will overrepresent individuals with knowledge about an upcoming jury trial. Mm, no, because how do you know that the person's going to have knowledge? It's just a random phone number that's called. So I don't buy that either. This court does not have complete survey data and therefore cannot adequately compare data among the four surveyed counties. As defendant acknowledges, this high-profile quadruple homicide case has captured the attention of the community, the state, and the country, and even beyond the United States. It has. It's nationwide or worldwide. People are interested in these cases. And this one's high profile, so yeah, it gets talked about on YouTube channels from all over the world and people on other social media all over the world talking about these things. Given the amount of attention that this case has received across the entire state, there are two critical questions on defendant's motion to change venue. The first question is whether a fair and impartial jury can be convened in Latah County, and if not, the second question is whether an alternative county would better safeguard defendant's right to a fair and impartial jury. Well, I think they already established that in their motion, that they don't think he can get a fair trial in Latah, and that's why they're asking for Ada County. Yet the state and the court were not provided a comprehensive list of survey responses across all four of the counties surveyed. In fact, Dr. Edelman's report focused primarily on Ada County as an alternative venue, despite the fact that Canyon County and Bannock County, excuse me, the other two counties surveyed both received astronomically less media coverage than Latah and Ada County. Astronomically less. He's got to throw in there astronomically less. They might have, but the population, the population of people in those counties is so small that he explained in his report that it's not necessarily neither of those, Canyon or Bannock, would be good because they're much smaller. Whereas Ada County, it's like 100,000 or 300,000 people, I think, versus like the 20,000 in Latah. And I don't remember what the other counties were, but and don't quote me on those because my brain changes things. But I think that's kind of what they had said in the motion to change venue. 20 and or 20,000 and 300,000 or something like that. It's a big difference. It's a big difference. And that's why Ada County would be better because you have more people to call from. But anyways, an example of the incomplete data provided from Canyon and Bannock counties is found on pages 50 to 51 of Dr. Edelman's declaration, where he reports that in Canyon County, approximately 90% of the jury eligible population there had read, seen, or heard about the case, and 51 followed the case somewhat or very closely, and that in Bannock County, approximately 84% of the surveys recognized the case, with some 14 percentage points lower than in Latah County. Just 45% of the survey respondents followed the case somewhat or very close. However, when Edelman discusses the Ada County survey respondents, he reports that while Ada County had a 93% recognition rate, there were important differences between the Latah and Ada County jury pools. Ada County residents are far less invested in the case. This is this is part of the reason why. I mean, part of the argument. Only 15% reported that they followed the case very closely, compared to 29% of the Latah County residents. In an unclear, blah, blah, blah. It is unclear why the court has provided the statistical number of survey respondents who followed the case very closely in Ada County. Yet in Canyon and Bannock County, the somewhat and very categories were collapsed, creating a larger percentage. This piece of context is especially concerning given the defendant is advocating specifically for a venue change to Ada County, despite the fact that Ada County has a slightly higher prejudgment rate than Latah County and a higher percentage of case recognition than either of the two alternatives. Additionally, Dr. Edelman discusses the phenomenon of minimization effect. This is when a prospective juror attempts to minimize the full extent of their exposure to pretrial publicity. However, his discussion about the impact of this phenomenon on the actual survey respondents in this case was limited solely to Latah County. Similarly, as discussed in more detail below, nowhere in the survey report is there mention of answers provided by Canyon County or Bannock County. And they probably didn't because they were making a recommendation. So they already reviewed the data from Canyon and Bannock and determined that it was not comparable. It wouldn't be a good option. So he didn't, I think, go into all the detail with County or Bannock. That's my or that was my thought, anyways, because why he's trying to make the case to go to Ada. So why talk about Canyon and Bannock other than in, generalities. All right, anyways. So where was I? Similarly, as we discussed in more detail below, nowhere in the survey report is there mention of answers provided by Canyon County or Bannock County survey respondents about the two most potentially prejudicial and inflammatory pieces of media information addressed by the media. Rumors that defendant had stalked one of the victims or followed them on social media. Okay. I don't know why that particular piece of information is, he's saying they're the two most potentially prejudicial and inflammatory pieces of media information. I don't know about that. Explain why those two are the two ones that are most potentially prejudicial. I mean, he's not, I don't, this is, okay. His arguments are bleh. Sorry. Give me 1 second. I need a break. All right, sorry about that. Um, so I did uh go back to um the defense's motion for change of venue, and I mean they do lay out a lot of different facts and things all over the place, so I'm not going to go back and like read it all to you um and to try to dispute anything that Bill Thompson might be saying, but Mhm. Oh, running low on oxygen. So somebody's getting it somehow. All right, so um this particular chart or pie chart is volume of media coverage per county out of the counties that they chose versus the rest of Idaho. So if you could see, I mean, there's a huge reason right here is that the media coverage alone is a huge portion of versus the population. Excuse me. Whoa. Okay. Sorry. Here's more opportunities to be seen. So obviously, it is way more, there are way more opportunities if you live in Latah to see some kind of news report or something along those lines. And I'm not going to go through the whole thing, but I really think that Bill Thompson is being disingenuous with some of the claims that he's making because I don't recall them saying some of the things that he's trying to assert in his filing. So that will be for Ann Taylor and him to argue out in front of Judge. All right, let's continue on. So, in an environment where the court has limited data, excuse me, I like almost passed out because I was like running out of oxygen before. So now my body's like making up for it by yawning, and I apologize. All right, in an environment where the court has limited data and where a defendant is asking the court to move venue to a county with a slightly higher prejudgment rate among survey respondents with knowledge of the case, these types of omissions make it impossible for the court to make an informed determination whether to move venue at all, much less to move it specifically to Ada County. This next section, titled The Majority of the Survey, focused on prospective jurors' knowledge of information already within the court record and admissible at trial. Defendant argues in his brief that this matter is an extreme case justifying a change of venue due to the continuous nature of media coverage, often inaccurate and misleading, the impact of the media coverage, and the small size of the community. Yeah, those are all contributing factors to uh, prejudicial jury pool. But as Idaho appellate courts have repeatedly held, facts are prejudicial when they are beyond the scope of admissible evidence or inaccurate. Mm, okay. When reviewing the nature and content of the pretrial publicity, this court is concerned with the accuracy of the pretrial publicity, the number of articles, and whether the articles will condition the jurors to accept a particular version of the facts at trial. Qualitatively, the courts must be concerned with news stories and editorials that are inflammatory, inaccurate, or beyond the scope of admissible evidence. And a lot of the things that were circulating around in the media, especially in the beginning, were inflammatory, inaccurate, and would never be allowed in evidence. So I think this just proves the defense's case, but the prosecution has a reason why they're bringing it up for some reason. All right. During the course of Dr. Edelman's survey, respondents were asked whether they had read, seen, or heard about a series of factual information items related to the case. The majority of these items, the cell tower data, showed that the defendant was near the victim's home several times in the month before the homicides. that a knife sheath was found at the scene, the crime scene. That DNA found on the knife sheath came back to match the defendant. That defendant drove the same type of vehicle seen in the neighborhood of the homicides. That defendant was arrested at his parents' home in Pennsylvania, and that defendant has stated he was out driving alone on, I believe they mean to say, on the night of the homicides, and part or are part of the court record and admissible at trial. So those are all admissible, I guess, part of the court record. Um, I guess this is admissible because they put it in the PCA that he drove by multiple times in the neighborhood, but that doesn't, they actually only said that his phone may have been in the vicinity of that phone tower. Doesn't necessarily mean he was by that home, but they tried to bolster up their PCA and get an arrest by saying, oh, yeah, he was near that home 12 times or whatever. It's totally okay for cops to lie, apparently, on their, or embellish truths on their PCAs, I guess, in a lot of places. All right, so only three of the questions asked were not part of the court record. These questions were: have you read, seen, or heard if university students in Moscow and their parents lived in fear until Bryan was arrested? Have you read, seen, or heard if Bryan stalked the victims? Have you read, seen, or heard that Bryan had, or if Bryan had followed one of the victims on social media? Because those are all rumors, questions, not necessarily anything that has been confirmed at this point in time. According to Dr. Edelman's report, 45%, that's less than half, of Latah County residents survey responded yes when asked if they had read, seen, or heard that defendant stalked one of the victims. The report did not indicate the response rate for the other counties surveyed. Similarly, 45% of Latah County residents responded yes and asked if they had read, seen, or heard that the defendant followed one of the victims on social media. Dr. Edelman reported that only 35% of Ada County respondents reported having heard this information, but did not report on the responses from the other two counties. And again, I say because he had already made his case in the report that he didn't find them viable alternatives to Latah County. So, as to the question whether individuals had read, seen, or heard that university students and their parents lived in fear until defendant's arrest, overall response rates were not provided for any county. If in any event, the substantial majority of the factual information asked of the survey respondents was not beyond the scope of what will be admitted at trial. Most of the items were contained within the court record. As to the prejudicial items related to rumors that defendant had stalked one of the victims or followed any of them on social media, less than half of Latah County survey respondents reported even having heard of it. The data provided to the court demonstrates, if anything, the majority of Latah County survey respondents had not heard the most prejudicial and inflammatory information. Who says that's the most prejudicial and inflammatory information? So says you, Bill Thompson. That no one's determined that. I mean, there's no. How do you determine what's more inflammatory than others? I know. But he's not the authority on what's inflammatory and what's not. So he can't really be making those claims. But anyways, I have a problem with that. Da 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 da. Where did we leave off? I hate when I leave off in the middle of a sentence. I gotta start back over all the way back here. All right, so the data provided to the court demonstrates, if anything, the majority of Latah County's survey respondents had not heard the most prejudicial and inflammatory information pieces outside of the court record, and that Latah County residents who have heard about the case were overall statistically less likely to prejudge the defendant. I don't know where he got all that. Um, Again, I say Latah is so small and interspersed with people that know someone from the college or work at the college or whatever. The college makes up a huge portion of the viable citizens of Latah County that can be sitting in a jury. So there's that too. You don't want someone from the school being on the jury and then think, or someone somehow related to the school, University of Idaho, to be like, yeah, I'm going to get on that jury and make sure that he goes down for it. Anyways, all right. So most of the items were contained within the court record. Sorry. As to the prejudicial items related to rumors the defendant had stalked one of the victims or followed any of them on social media, less than half of Latah County survey respondents had heard that. Um, did I read that whole thing? I did. Sorry. The court should decline defendant's invitation to disregard long settled precedent establishing voir dire as the proper procedure for addressing bias. Voir dire is the process in which you select your jury. Um, so the court should decline defendant's invitation to disregard long settled precedent establishing voir dire at the proper procedure for addressing bias. The survey relied upon by the defendant did not even ask respondents the most crucial question of all, whether they could set aside their biases and base their decision only on the evidence at trial. But that's you weren't trying to find a juror, and that is, like I said already in my arguments earlier in this video, that is really a low standard. You probably want jury to your juries your jurors to have little to nothing no knowledge of the case before they're about to go in front of, because any like I said, any little thing that you hear could prejudice you, even if you can say I can set my feelings aside. Not too many people can actually do that, or it takes a emotionally intelligent person, I should say, to do that. All right, so instead, defendant and his experts ask this court to simply assume that the survey respondents, and by extension all potential jurors in Latah County who have been exposed to media information about this case, are incapable of setting their biases aside and serving on a jury. But I don't think that they needed to establish that somebody could set aside those things. I don't think that was necessary to prove that there's more media saturation in Latah County. In Dr. Edelman's declaration, he argues that a juror's professed ability to be fair and impartial should not be taken at face value in cases where there is substantial prejudicial pretrial publicity. Similarly, Professor Scott Sunby argues generally that small town residents where crime is committed cannot be impartial jurors and will go into the proceedings with a thumb on death's side of the scale, meaning they're ready to convict, I guess, and maybe even condemn them uh, to death row or something. I don't know. All right, so Sunby asserts that there are two distinct dangers to holding the trial in Moscow. First, Sunby argues jurors will be aware of community outrage and, as a result, might fear being outcast if they fail to return a sentence. In support, yeah, so they want this person executed, and can be up in for the running of execution as well because of the nature of the crimes. Whether he's guilty or not, he could be sentenced to execution. Right. In support of this assertion, Sunby provides a single example, the Arkansas case of Bobby Ray Fretwell, whose execution was commuted after a juror came forward and admitted that he had voted for the DP for the sole reason that he feared being ostracized in the hometown and that he shared with the Fretwell's victim. Yeah. D-row inmate spared after juror makes plea. And that was an article. There's a link to it in here. All right, setting aside the obvious issue with asking this court to base a legal decision on a single news story and involving a nearly 40-year-old case that is not binding on this court, there is a glaring distinction between the Fretwell case and this case, the advent of social media and the internet. Assuming the 1984 homicide went to trial in the middle of the 80s, it is virtually certain that media coverage was more localized to the community rather than spread out across the state of Arkansas or the country. I mean, that's a good point, actually, but I still don't agree with most of what he says. Thus, had a judge even been asked to change venue in that case, it is entirely likely, in the absence of pervasive media coverage, a different county may well have had a population that had largely not heard of the case. That simply isn't the case in this matter, where a significant number of individuals in every county surveyed were familiar with the case. Thus, it is a poor analogy that has no legal or factual relevance to this case, so says Bill Thompson. Second, Sunby argues that the homicide of University of Idaho students created a uniquely traumatizing effect on the city of Moscow, effectively rendering potential jurors victims once removed, meaning they feel like it happened to them because it happened in their town. It happened right next door, if that makes sense. So, in support of this assertion, Sunby offers another faulty analogy, claiming that trying this case in Moscow would be tantamount to allowing a guard who worked in the same prison to serve on a jury where a defendant was on trial for the homicide of a prison guard. But that analogy is flawed because it does not take into account the court's ability to convene a large enough jury pool to prevent anyone with such a close connection to the case to sit on the jury. And how long is that going to take? And how many resources? I mean, I know it's a lot of resources to move to a different county too, but you got to weigh your time and money, and it's going to take time to find people that haven't heard of this case in that area or could put aside their bias and don't know someone who knows someone in this case. It's going to be difficult because of the many, many connections to the university. Similarly, after arguing that exposure to media creates biases that are different to overcome, Dr. Armani L. Alei concludes that venue should be moved outside of Latah County. Dr. Alai, Alayi, I don't know, Alayi, specifically argues that even extended voir dire by seasoned attorneys does not specifically mitigate pretrial publicity effects despite its other potential benefits. How, yeah. Oh, okay. So I'm like, how is that helping the state's case? No, it doesn't, because Dr. El Elahi said that. Um, and it makes sense. Even extended voir dire by seasoned attorneys does not specifically mitigate pretrial publicity effects despite its other potential benefits. So even if these attorneys are well seasoned at the voir dire process and can really weed out the people that um, are not, uh, shall you say, I guess, bias or have some kind of connection, affiliation with the school or someone that knows someone that was affected. Um, yeah, they need. Sorry, I totally lost my train of thought there. Um, but that he's saying that the even these excellent, well-trained attorneys could still have difficulty finding an unbiased jury through the process of voir dire. It doesn't always mitigate the problem. The problem with the defendant's experts, however, is that their opinions are directly contrary to the law. Oh, really? The United States Supreme Court and Idaho appellate courts have repeatedly held that a prospective juror may remain on a jury panel if a trial judge is persuaded that the juror can set aside their initial impression and render a verdict solely on the evidence presented at trial. But the problem is a lot of people say that they can and they can't. That's the problem. You don't, if you can avoid people having heard of the case, that's what you would prefer. Someone coming in completely blind, not knowing anything about it. I mean, that's the ideal juror, obviously. As the Idaho Supreme Court held in State versus Hairston, the trial court does not need to find jurors that are entirely ignorant of the facts and issues involved in the case to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of the prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Again, I mean, they're making the case that they really need to be able to set their feelings aside, which a lot of people can't do. And if I was Ann Taylor, I would bring that up. You're asking them to really be honest about that when we all have biases coming in. And I think it's very prejudicial having seen the amount of media saturation per the rest of Idaho versus Latah County. It's ridiculous. Go back to the chart. Where'd it go? Uh, Here, media coverage by county. Rest of Idaho is 31%. Latah County beats it by 36%. Volume of media coverage per county. I mean, just saying. And while I know that Ada is the next in line, the population still is, and I double checked, it's 400,000 in Ada. So I did verify that statistic for us. It's over 400,000 people in Ada, which is another good reason to move it there if you were to move it. I have a feeling it's not going to get moved. If I were to take a guess, I think Anne had some good points, but Bill's gonna argue what Bill's gonna argue. Same court explained in Haddon it will only be at the commencement of voir dire that the court and the parties will be able to determine if any of the prospective jurors have formed an opinion based upon adverse pretrial publicity. So what, you're supposed to have your voir dire first, and then when you're like, oh wait, they're too prejudicial, uh, we'll move it now? No, I mean, you want to know that you're going to move it before you move it, I would think, with good reason. All right, so only then can a court determine whether the atmosphere of the court will be so utterly corrupted by press coverage that an unbiased jury cannot be found. Thus, as the state has previously argued, even if the court determined that a change of venue would be necessary, the only appropriate way for the court to do so would be after commencement of voir dire. So now they're saying you can't even do it until voir dire happens. The court can fashion remedial measures for jury selection short of changing venue. Because the court has not been presented with evidence that a jury pool in Ada County would be any less likely to prejudge the defendant than one in Latah County. The best way to ensure that the defendant gets a fair trial is to safeguard the jury selection process. First, the court can convene a large jury pool. As noted elsewhere in the brief, if the court were to summon 1,800 jurors, only one in 100 would have to be chosen in order to select a jury of 12 plus 6 alternates. Next, the court would send out questionnaires to each of the jurors to gauge knowledge of the case, the media exposure, biases, and other views. The court could then allow the parties ample time to review each questionnaire, and the parties could then confer to discuss whether they had reached any stipulations as to the disqualifications for cause. After that, the court can take up the issue of any disputed jurors and determine whether to dismiss those jurors for cause. Then, those jurors whose questionnaires passes initial review could be called back to the courthouse for actual voir dire. So he wants a whole process put in place here. The court could also allow a detailed individual voir dire outside the presence of the other jurors, which would address concerns outlined by Dr. Edelman in his report, explaining that research shows that prospective jurors are more likely to be forthcoming and candid outside the presence of other prospective jurors. If the court were inclined to allow the trial to be live streamed, the court would make an exception for individual voir dire and disallow any recording of the individual voir dire to ensure that each juror being questioned would be maximally incentivized to freely and candidly answer questions asked of him or her. Not for protection, but so that they can be candid. Even if the court were to find that a fair and impartial jury cannot be impaneled in Latah County, the court may impanel a jury from a neighboring county rather than moving the trial 300 miles south. Even if the court were to be persuaded that a fair and impartial jury could not be impaneled in Latah County, the court could rely on Idaho Code 1918-16 and draw upon a jury pool from a neighboring county. To invoke this code, the court must find 1. A fair and impartial jury cannot be impaneled in the county where the criminal complaint information or indictment was filed. Number 2, that it would be more economical to transport the jury than to transfer the pending action. So instead of everybody moving to Ada County and holding up in a hotel somewhere or motel, then you would just have the jurors being bussed either daily, or they would probably not daily for a 300-mile away trial. They would probably um, put them up in hotel rooms, and allow them to be bussed in from the hotel every morning to the courthouse. I see 1918-16 as explained in more detail in section 2 below. The transfer of trial to Ada County would come at an extraordinary cost. Transporting the jurors from a neighboring county such as Nez Perce County, sorry guys for any mispronunciations, would be a far more economical option. Similar in population size to Latah County, Nez Perce County has a population of over 42,000 United States Census Bureau data. Lewiston, the largest city in Nez Perce County, is approximately 30 miles from the Latah County Courthouse. Summoning a jury panel from across the county line would incur far fewer costs and logistical issues than moving the trial to Ada. So instead of bringing in people from Ada, he's saying bring them in from a neighboring county so that it's more cost effective. It may be a little bit more of a drive in the morning, but they get there. You know, you get all 16 of your jurors there every day with a bus. Transferring venue would not be convenient for the parties and witnesses, nor would it be in the interest of justice or the interests of justice. Defendant next argues that the court should change venue under Idaho Criminal 21B, which provides that upon defendant's motion, a court may change venue to another county for the convenience of parties and witnesses in the interest of justice. The Idaho criminal rule addressing venue is distinguishable from its civil counterpart, Idaho Rule of Civil Procedure 40.1, which also allows for a venue change for convenience but is limited in scope to the convenience of the witnesses and the ends of justice. Defendant does not even address the convenience of the parties and has failed to establish that a change of venue in this case is convenient for the witnesses or in the interest of justice. Um, okay, so they were supposed to tell you in her motion it, how people were going to be inconvenienced. That's how he wants it to be. Okay, we can tell you what inconveniences us about Idaho and their jury system, their court proceedings, law enforcement. First, defendant argues that Ada County's large population size has more than 10 times as many potential jurors than Latah County and thus offers a larger jury pool to choose from. But the fact that Latah County is smaller than Ada County does not mean that it is too small to select a jury. As the 11th most populated county of Idaho's 44 counties, Latah County is larger than 75% of Idaho counties. Latah's jury eligible population is over 32,500, could easily be accommodating to a panel of hundreds or even thousands of individuals being summoned for jury duty. As noted above, if the court were to proceed with a 12-person jury and 6 alternates, the court could easily summon 1,800 individuals, only 5% of the Latah County total during eligible population, meaning that out of every 100 jurors called for duty, only one would need to qualify to be able to seat a jury. You're going to go through that many people? I mean, do you want to go through that many people to seat a jury? Next, defendant argues that the Ada County Courthouse can best accommodate this trial, specifically Ada County's large courtrooms with adequate space for attorneys and room for spectators. I think that's a great point too, because you're going to have people coming in from all over the place trying to be in the courtroom. And doing it in the larger courtroom and the more advanced courtroom with like the best technology, the best, setup, everything is really going to be important. You don't want a crappy setup. Look at the Karen Reed setup and how originally the one room that they were supposed to be in, 4 of the jurors would see the back of the witnesses' heads. How they've been doing trials in that court for hundreds of years, I don't get because people aren't seeing the jury's faces or the witnesses' faces. And that's a big part of finding out if determining someone's credibility, I should say, is body language. Um, so you really and then they got moved to like the smaller courtroom where it's like an even crappier setup, but at least the jury could see the faces of the witnesses. So you have to be careful what you wish for too. You might get put into a different room that's even crappier. I don't know. I'm just saying you want to know if you're going to change venue, you want to make sure that you're going to a room with a good setup and good layout, good acoustics, good everything. You want everybody to hear everything. All right. So I, excuse me, even in Ada County, but even Ada County cannot accommodate every interested spectator. One merely had to drive by the Ada County Courthouse during certain days in the Lori Vallow trial in 2023. Was that where they were? The Ada County? That's why it sounds familiar. And the Chad Daybell trial earlier this year to see a line out the door. The public interest in attending the Chad Daybell trial was so great that individuals who wished to attend had to apply online for a reservation the day before to get a ticket into the courtroom. So you're making the case for the fact that she needs a bigger courtroom by saying, look at the spectacle Chad Daybell's trial was. We don't want it to be like that, Judge. But yet you're going in a small courtroom, the smaller courtroom. I mean, granted, that's what they have. That's what he's wanting is not a bigger room to accommodate and um, whatnot. So, anyways. Chad Daybell's trial will be live streamed. Here's what you need to know if you want to be in the courtroom. That was what the mm, promotion said to get people to sign up to be in the courtroom. That's so odd. Like putting in your number, like pick a number to get served so you can go into the courtroom and watch the trial. Anyways, where were we? East Idaho News, that's where that was from. On cases of such tremendous public interest, there is little. Why is my brain putting words? My mouth, sorry, is putting words that my brain is not seeing or something. There's a disconnect there. On cases of such tremendous public interest, there is unlikely to be any physical courtroom large enough to accommodate every member of the public who wishes to observe. Moreover, the court can accommodate the large number of people who want to view the trial by providing live streaming options, and he's doing so on his very own YouTube channel, Judge. As to the size of tables for the attorneys, the location of media, and the daily workings of security, these logistical considerations can be addressed by careful planning with the local trial court administrator and the administrative district judge. There is no reason to think that the Latah County Courthouse or its staff is incapable of addressing these administrative and procedural matters in the months leading up to trial. Indeed, when defendant filed a motion to remove cameras in the courtroom after media outlets repeatedly took close-up photographs of the defendant in violation of a prior verbal admonition of the court swiftly denied multiple subsequent media requests and eventually issued its amended order governing courthouse and courtroom conduct, which prohibited the media from video recording. That's crap. Um, Still photography or audio recording. They couldn't even do still photography or audio recording? What the heck? There is no reason to believe that any subsequent concerns about media or security would not be addressed with similar efficacy. Defendant also argues that this case should be moved to Ada County based on cost. Defendant's argument is limited to asserting that out-of-state witnesses who fly into Boise would be closer to the physical location of the courthouse, while Latah County witnesses would potentially have to fly to the Spokane airport and rent a car. The state does not dispute that the Spokane airport is further from the Latah County courthouse than the Boise airport is from the Ada County Courthouse. However, the nearby city of Lewiston also has an airport serviced by Delta and United with nonstop flights to Denver, Seattle, and what are you putting out an advertisement for them? Yeah, they put their website out there. But whether out of state witnesses fly into Lewiston, Spokane, or even Boise, the cost of rental vehicles for a handful of out of state witnesses is only a fraction of the total cost picture. Most of the state's witnesses are local or will be traveling to Moscow by car. If venue is moved, those witnesses who are local would need to rent hotels in Boise, potentially for multiple nights while they wait to testify. I'm sure Boise would be happy about that. The state's law enforcement and emergency dispatch witnesses would have to potentially be away from work rather than hours, creating a ripple effect of inconvenience. Similarly, the medical examiner who is based out of Spokane would also have to extend her time away from the office. Some witnesses who would otherwise drive to Moscow from Spokane or northern Idaho would have to obtain flights if the trial were moved to Boise, which would increase the costs. While defense counsel took this case on a contract basis and will have to travel whether the trial is had in Ada County or in Latah County, the same is not true for the court reporter, the court clerk, and the court's staff attorney. All would have to travel to Boise either by air or in a state vehicle, would have to obtain lodging, and would have to arrange for per diem reimbursements for meals. The state, which has the burden of proof and must deal with the logistics of juggling witnesses and trial exhibits, would have to relocate both of its lead attorneys as well as its support and victim services staff for weeks and likely months. This would come at a great expense for lodging, transportation, and per diem. Additionally, the elected prosecutor and his chief deputy would be physically away from the daily operations of the Latah County Prosecutor's Office and from the law enforcement agencies they advise, creating a potentially detrimental ripple effect for Latah County's public safety operations. And finally, the defense also asks the court to change venue on the basis that Moscow Police Chief Fry is currently running for Latah County Sheriff. First, this presupposes the outcome of the November election and is premature. If elected, if elected as sheriff, Chief Fry would have the statutory authority to summon a sufficient number of trial jurors in the event that there is an unanticipated shortage. Defendant states that Chief Fry is a witness and therefore this duty would create a conflict. Yes, exactly what I was thinking. At this time, the state does not anticipate calling Chief Fry as a witness. However, even if he were called as a witness to the defense, and even if there were an unanticipated shortage of jurors, he could delegate his authority to a senior chief deputy to exercise that function if necessary. That was a very long worded thing. All right, so the court should also consider, in the interest of justice, the physical location of the victims' families. ICR 21B, interest of justice, a consideration in a court's determination whether to change venue for convenience. It is the state's understanding that most of the victims' immediate family members who are constitutionally entitled to attend trial proceedings live closer to Latah County than to Boise. So they're really pushing for we need to be closer to Latah, which I get because of the expense and everything. But if your population is a half hour away, that's where you got to go for your people, your jurors. It is also strange to the state that the surveyor did not do polling in geographically closer counties such as Nez Perce. Given how close the overall judgment rates among the surveyed counties were, it is entirely possible that Nez Perce County could have had an even lower judgment rate against Karen Reed than the one in Latah County. If the court were to change venue, it seems to the state that changing venue to a geographically closer county, such as Nez Perce or Kootenai, I was going to say Kootenai, that's not it. Kootenai County, I think, just across the state line from Spokane International Airport, would be less inconvenient than moving the trial 300 miles south to Boise. In any event, the defendant has come nowhere close to demonstrating that moving this trial to Boise would be convenient to the witnesses or the parties, nor has the defendant demonstrated such a move would be in the interests of justice. Defendant has failed to meet his burden of showing this change of venue in this case is necessary or convenient. The court should decline his invitation to ignore well-settled precedent establishing the voir dire process. The court should also decline to relocate itself, the state, and scores of witnesses hundreds of miles, only to face another jury pool with similarly high media exposure. Defendant motion should be denied respectfully. And it is signed William W. Thompson Jr. and Ingrid Beatty. Both are the prosecutors in this case. Bill Thompson is the lead prosecutor. What do you guys think? Should this be denied? Should she just throw it all out and say, to hell with it? What do you guys think? I mean he, Judge Judd. I've had so many cases where my judges are females lately. I meant Judge. Will he throw this out, or will he actually choose to change the venue? I I feel like he's not going to, because they already discussed it in one of the hearings that we covered, where he made it seem like he wasn't too keen on the idea because he didn't want to move. So I have a feeling that that's going to prejudge his or bias his conclusion in this, his order. So that is the end of the state's, whatchamacallit, the state's objection to the motion to change venue by the defendant, Bryan Kohberger. Let me know in the comments below what you think, if it will get granted, if it will get denied, and I will see you guys in the next video. Take care. Thank you. Bye now.